Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello, it's 18 months since we last discussed the post office scandal, but a lot more has been revealed about it in the public inquiry, which is still going on. To discuss where we are now, I'm joined by my co-host Rob Allen and by two dedicated post office inquiry watchers, Professor Richard Moorhead of the University of Exeter and John Hyde, who's writing on it for the Law Society Gazette. Rob, can you just remind us what this post office scandal is about?
Well, this is a very long-running saga which centres on the post office accusing hundreds of postmasters and mistresses of stealing money from them, when it turns out that, in fact, the losses that the post office thought they were suffering arose from a faulty computer system called Horizon, which had been developed by the computer company Fujitsu.
The post office inquiry has been going on ever since we recorded the last episode on this subject. What has struck you most about the fallout from it?
Well, I suppose there's been a fairly constant stream of pretty shocking revelations and allegations, but the thing that surprised me most was how quickly Parliament decided to act to overturn decisions made by courts, which I think is unusual, maybe unprecedented.
John, 8 months ago, the ITV series Mr. Bates versus the Post Office was a big success. Has it actually changed anything about the inquiry itself?
Well, it's changed the scrutiny from the media and the public overnight. I went to several hearings in the second half of 2023. Quite often it would just be myself, Nick Wallace and Carl from Computer Weekly, and we sort of had our run of the place. The first day back after the drama, you could not move in the press gallery. It was like trying to reserve a deck chair on holiday. And one cameraman pulled me aside and said, "Is this the start of the inquiry then?" I said, no, this has been going 2 years already. So the level of interest was remarkable. And Parliament obviously acted with some speed. But of course, that was an option that was open to them for many years before. And so without that drama, none of those convictions were overturned in the time that they were.
Richard, is this kind of change of interest a source of cynicism or joy to you?
It's a source of joy to me. I think it's fantastic that the story has got the attention it has done. My only worry is that will drop off, as it will inevitably drop off. How much will it drop off? John's absolutely right. It made a massive difference to things like the quashing of convictions, and it's increased the scrutiny on compensation. So the drama completely transformed the level of debate.
And it was really interesting talking to the sub-postmasters who come every day, in some cases, to the inquiry. And there was this narrative afterwards saying, they must be so annoyed that it took so long. They must be so frustrated. And actually, it was just pure joy on their part. And of course, they would rather it had come out earlier, but I don't think we should underestimate how affirming this has been for the victims, and it's actually been a pleasure to see their joy at how the inquiry has gone since January.
The other thing that's worth saying about the drama is I think it's very true to the story, both the story emotionally and the actual facts. They did a really incredible job.
I mean, each of you've both covered and followed the inquiry pretty closely. We want to focus really on what's come out about lawyers, legal representatives in this discussion. Richard, from your point of view, what has surprised, shocked, concerned you most about how lawyers in various roles have behaved during this saga?
The thing that's shocking is it steadily got worse and worse. Okay, so when I first started writing about this, it was about 5 years ago, and things looked quite bad. That was just after the Bates judgment had been published, with all the things that the judge, Mr. Justice Fraser, set out that the lawyers had got wrong. They'd misled the court. The case was run on a scorched earth basis, etc., etc. So it was the depth and scale of the problems, which I think is really shocking, touches junior lawyers, senior lawyers, brings into play a former president of the Supreme Court even. Now, not all of those have done things wrong, but some of them have. Some of them have committed professional misconduct. Some of them have probably committed criminal offences. So it's quite difficult actually to take it all in.
Mm. John, from your point of view, what's been the sort of standout thing that's shocked you most, do you think?
I think the overriding disappointment almost is you expect the conduct that's happened of certain people within the post office. You're not surprised by it. Corporate greed, a management cover-up. The difference with lawyers that have been involved is they were supposed to be the gatekeepers, the sort of ethical, moral gatekeepers. They were supposed to be the ones who turned round to the management, to the investigators, to the corporation to say, no, that's not on, that's not acceptable. And I suppose overall, what's so shocking is that there doesn't appear to have been anyone that was prepared to stand up to the corporation and say, this is wrong, this has to stop. And I think that's shocking because that suggests that there's some endemic problem within the legal profession and within the lawyers who took it in turns to do nothing.
And by the lawyers, you mean lawyers who are employed by the post office or taken on by the post office to provide legal advice?
There were both types of lawyers working for the post office, and there doesn't appear to be much difference in terms of the ethical standards that lawyers kept to. It crosses over in-house and external lawyers equally, I would say.
And John, post office in-house lawyers and investigators appear to have deliberately hidden information and documents. Can you give any examples of how that failure of disclosure led to people being convicted in the criminal or civil courts in the original cases?
There was one particular solicitor who was presented with an independent expert's analysis which said that Horizon had problems. And her response, which was referred to in internal emails, was to ask how much to make this go away and keep it out of court. So even back as far as 2003, 2004, there were opportunities to step in and say these convictions potentially aren't safe. We then travel forward in time with Seema Misra case. There was a particular solicitor, a chap called Jarnail Singh, and the evidence showed that the document that he was sent, which showed there were issues with Horizon, was saved onto his hard drive and was printed in the post office within minutes of him receiving it. Singh said he did not know how to save documents and he didn't know how to print documents. Now, that's his evidence to the inquiry and the...
But what difference would that document have made?
We'll never know. The court may have found Misra guilty or may have accepted a guilty plea, but the key is the defence did not have the full picture about the issues with Horizon that were known to the post office and to Fujitsu. And I think the shocking part from our point of view was the fact that prosecution lawyers were told these are the issues with Horizon and they did nothing, it would appear, to disclose that to the defence team. And that could have prevented so many people from being convicted and could have prevented Seema Misra, for example, from going to jail.
I mean, Richard, this seems a bit of an odd question, but how serious is that failure to disclose? Could it amount to perverting the course of justice, a criminal offence, or is it just one of those things that happens and is just accepted as part of what happens in trial proceedings?
It depends on what you think the state of mind of the lawyer is. So did they knowingly or recklessly not disclose that document to try to get Seema Misra prosecuted, or did they simply overlook it or not understand it? If it was deliberate or reckless, then that is very likely to be a criminal offence in those circumstances. It's also worth saying that that pattern of not disclosing evidence is rife in the post office cases. So some of the witnesses get taken through example after example of situations where they did not disclose information, and they tend to say, oh, well, with the benefit of hindsight, I can see that should have been disclosed, and can't really explain why they didn't do it at the time. So there's a whole raft of those kinds of examples where lawyers are just basically looking for any reason they can find, good or bad, to say to typically a high street solicitor, no, you can't have that information for your client.
And when Richard talks about the state of mind of the lawyers involved, there was plenty of evidence in the form of internal emails which showed an almost celebratory tone taken by lawyers, not by post office officials, not by investigators, but by lawyers. So the lawyer who was involved with the Misra case, there was an infamous email that he sent to senior colleagues at the post office within days of her conviction, which said, effectively, hopefully this will stop the horizon bashing bandwagon. And that doesn't strike me as someone who was thinking about these cases being handled properly and justice being done. It strikes you as someone celebrating. And in some cases, it felt like lawyers were almost trying to gain approval from their senior post office colleagues, and sort of saw one way of doing this as to sort of show, look how many convictions we managed to get. We managed to get another one over the line. And this was campaigning as much as legal work.
Or like a game, which you've got to win, but the price is the imprisonment of, in this case, Seema Misra was a mother, wasn't she?
Seema Misra had one child at the time of her conviction and was pregnant with another child. She was jailed and she gave birth still wearing a tag. And the Singh response of, hopefully this will stop the horizon bashing bandwagon, is really indicative of how important the Misra case was. This was their chance to show all the other postmasters who were contemplating fighting their cases that you are going to lose and the post office will bring you down. And lawyers really bought into that narrative and in some cases actually added to it and fed it.
I mean, Richard, one of the things that strikes many people as odd, me I guess among them, is that the post office themselves were the people doing the prosecuting, even though they were the victims of the alleged offences. Has the inquiry raised any sort of serious questions about that issue of private prosecutions and an organisation having powers themselves to investigate and prosecute like the post office?
So it certainly looked at the post office as prosecutor. It's worth saying that cases weren't prosecuted privately in Scotland. They were prosecuted by a public prosecutor and with the same kinds of results. I don't think it's really about private prosecution. I think probably what is important is that the post office had its own team of investigators which created facts on the ground which were deeply, deeply problematic. And then the prosecutors, be they public or private, sort of accepted those and ran with them to grind guilty pleas out of the sub-postmasters and sub-postmistresses.
John, in our previous podcast, we discussed whether defence lawyers representing the sub-postmasters and mistresses could have done more to prevent the many miscarriages of justice. Has the inquiry looked at that question at all?
Not in a great deal of detail. I think there is a certain amount of sympathy towards defence lawyers who were involved in this, partly because there was a significant failing in disclosure. So you are being told the system is correct, Horizon is faultless, and the data cannot be questioned. It's difficult in those circumstances to mount a defence on that basis, and it's understandable that they took the option of advising clients, look, come to a plea bargain, try to reduce the sentence you're going to end up with. There's so much for this inquiry to cover. I think the benefit of the doubt has gone with the lawyers who defended postmasters many years ago, and they just didn't have the information that they should have done. And so really, again, the blame switches to the post office.
Richard?
I do think it is a bit of a neglected question. We've been doing a bit of a work in our research project talking to sub-postmasters about their experience of lawyers generally, including their defence lawyers. Generally, the sub-postmasters feel quite positively about the lawyers that have represented them at all the different stages of the cases that they've been through, but not always. There were clearly lots of them who felt that they weren't guilty, they hadn't been dishonest, and yet were encouraged to plead guilty to false accounting. I think John's right, that's a difficult one for a lawyer to advise on. But if you look at the actual facts and circumstances of the case and what the sub-postmasters were saying, I think it should have appeared more often than it did to the defence lawyers that those people had a defence to false accounting. The second thing I would say about it is, at the time when they were pleading guilty to keep out of jail. That was the horrible dilemma they were faced with. Many of them had kids. For understandable reasons, said, OK, I'll accept a guilty plea. What they didn't understand then, but they do understand now, is how profound that choice was in terms of their life now. The sense of shame, the stigmatization, the impact on their social lives and working lives afterwards was enormous. These decisions ruined their lives. And were they probably supported through that? I don't know the answer to that, but we're looking at it.
And I would add, because it's something that we campaign about, I've heard moving testimony about the impact of criminal records, because obviously you get a criminal record from the court conviction. I think one of them wanted to volunteer in a school and felt she would be barred from doing so.
Yeah, the shame and the stigma has hung around their necks for, up to 20, 25 years. And it's just been a disaster for them.
When it comes to defence teams as well, let's not forget that the Post Office informed each sub-postmaster and their legal teams that they were the only ones.
The only ones who are being accused of this crime.
The only ones who had a problem with Horizon, the only ones who were in that situation. It's easier now, obviously, to say, 700 people plus were wrongly convicted. But actually, again, when we look at disclosure, there was lots of evidence that the Post Office had collected which showed that there had been thousands of complaints about Horizon. That was never disclosed to the person in the next village, in the next town who was being accused. So again, there was this lack of transparency from the Post Office, which meant that these people had no idea that there were so many issues with Horizon all around them. And so defence lawyers, understandably, probably said, well, if you are the only one, then we can't really fight it. If they'd known that there were so many complaints, there were so many calls to the Horizon helpline, they would have been able to mount a much better defence. But there was actually one really interesting part during the inquiry when a solicitor said he didn't want to overwhelm the defence by disclosing.
So this was a Post Office solicitor said he didn't want to overwhelm the defence?
Well, it was an external solicitor working on behalf of the Post Office, and it was a civil case. It was the Lee Castleton case. And the solicitor said, I didn't want to overwhelm Lee Castleton and his legal team by disclosing thousands upon thousands of complaints, when, of course, the irony is the very disclosure of thousands of complaints would have shown to Lee Castleton and others in a similar situation the extent of the problems with Horizon.
I mean, is that a fair tactic on the part of prosecutors and investigators to say you're the only one when it's blatantly untrue?
No, if they know it's not true, that's professional misconduct. You can't mislead anybody, least alone your opponent. If they understood that it was wrong, and some of them clearly did understand that it was wrong. So I think that's fairly straightforward.
Again, that's what I mean by gatekeeper. There's every chance the Post Office or people within the Post Office would have said, let's just tell people they're the only ones. That's the point at which the lawyers needed to stand up and show some ethical backbone and say no and refuse to go along with that lie.
Yeah. Moving on to the judges who were presiding over the proceedings. I mean, there has been some criticism. Sir David Calvert-Smith, former DPP, Director of Public Prosecutions, looked at a number of them. I think he himself was a High Court judge. He feels that judges should have poked around a bit more deeply into the cases. Do you agree with that, or is our system not really geared up to judges poking around? They're more sort of referees between the two sides.
Well, I think both things can be true. I think the system is geared up to allow this sort of thing to happen, or makes this sort of thing more likely. It's run on a party basis, and the judge generally sits back. I think there are arguments that sometimes the judge should have noticed things or behaved differently. Seema Misra's legal team tried to get her trial stopped on the basis they hadn't had proper disclosure. And the judge waved them away, in essence, and said, go and talk to the prosecution expert and sort it out, please. This trial is going ahead. With hindsight, that was clearly a bad decision. With foresight, you might wonder too, because the case had a history of disclosure problems.
So did the defence in that case have an idea that there was a document which might have helped their case, or were they, as it were, just asking the question?
So they had a sense that there was documentation they weren't being provided with. The post office was saying, well, tell us what it is precisely that you're looking for. And they were like, well, we're not quite sure exactly what we're looking for, but we think there are these kinds of problems. And they were asking the right questions, actually. And the post office was stalling and saying they couldn't have the documents and giving various excuses. And a judge that was more seized of the facts might have been able to grasp that one better. But the system doesn't really allow the time for that. And judges aren't really very well resourced to be able to do that kind of thing. But there are times when they could have done more or done differently, probably. Why didn't a judge spot that Gareth Jenkins' witness statement wasn't in the proper form for an expert?
Can you explain what happened?
Gareth Jenkins was giving expert evidence for the post office. Expert witnesses have to give evidence in a particular form. They have to state they've done certain things, that they understand certain duties. Almost none of that was done in the case of Gareth Jenkins. None of that information, which you'd have expected to see in those statements, was in his statements.
So the judges took this person as an expert, but didn't challenge his basis for being so. So was he, a bogus expert? Or?
Well, he was an employee of Fujitsu who were running the computer system. And an expert witness is supposed to be A, expert, have the necessary knowledge to give an expert opinion, B, give a balanced opinion, and C, be independent. Now, the case law says it's possible for him to be independent if he's an employee, but all of the circumstances pointed to him not really being independent, and the way he gave his opinion was certainly not done in an independent and objective way. So, to give you an example, he didn't say some of the reasons why he might be wrong, which is what an expert witness is supposed to do. He didn't say where he'd got all his information from. So there were all sorts of problems with his evidence. If they were noticed, they were sort of brushed aside. And that's the basic problem when you've got a high volume system processing cases administratively rather than really stopping to deal with them properly.
Yeah, I'll do the sort of mandatory Jenkins disclaimer, I suppose. His argument was that he was not informed of his duties as an expert witness. So he said he was ignorant. He said he wasn't aware of the justice system. And again, this comes back to lawyers because he should have been told what his duties were. Now, you might say, well, it's common sense. You tell the truth, you give all the information that you have. But it was a legitimate point to say that he should have been told what his duties were explicitly by the lawyers representing the post office. And there was evidence that came out of the inquiry that he wasn't.
And his evidence was that there was nothing wrong with Horizon, and therefore it was critical in getting convictions and people losing their cases.
Well, sort of. So the other interesting thing about the process that John's described is that as well as probably not advising him on his duties as an expert, one of the lawyers in particular was encouraging Gareth Jenkins to be stronger in his evidence in support of Horizon than Jenkins was inclined to be. So there was a process of what a barrister in the inquiry called hardening up of the evidence, trying to get Jenkins to say things that were more strongly in support of Horizon than Jenkins himself was comfortable with. And some of those Mr. Jenkins agreed to because he could see no reason why he couldn't agree, and some of those he refused to do. So Jenkins was actually resisting some of the pressure from the post office barrister to try to toughen up his evidence in support of the post office.
Again, it does seem a slightly odd system that an expert witness whose duty is to the court is effectively hired either by the prosecution or by the defence and then expected to forget that when they're giving their evidence. So the pressure that you describe that this chap stood up to an extent is almost bound to be structurally in place, isn't it?
When he talks about the duties, I think his contention was, well, I was an employee of Fujitsu. I was brought in as an expert witness by the prosecution. I think he suggested that he wasn't aware that he was supposed to be independent and he had duties to the court. So in his mind, he was doing his job. A properly advised expert witness would have been aware that clearly you have to be independent and you have an ultimate duty to the court, which he did not fulfill.
I mean, one of the other judges who's been involved is the former president of the Supreme court, Lord Neuberger, who seems to have played a sort of questionable role in one of the cases. Is he going to be giving evidence to the inquiry, Richard? Do you know?
He's not going to be given evidence to the inquiry, and I think that's a misstep, if I may say so. I think he should have been asked to give evidence.
Could you explain briefly what his involvement was?
So he was involved in one particularly controversial moment in the Bates case. The Bates case was brought by 555 sub-postmasters and sub-postmistresses, essentially to sue the post office for losses caused by the faulty Horizon system. And that's the case that they effectively won at the second Horizon trial when the post office agreed to settle. After the first main trial, post office decided it wanted to appeal that case, and the legal team that had lost the case said, we think the judge behaved in a biased way and that we should think about trying to get him recused, which means try to get him to take himself out of the case. Lord Neuberger was brought in by the legal team to advise on whether there was a chance of success. Now, there are a number of problems with that. One is that Lord Neuberger is a former president of the Supreme Court. The second problem is the team that was saying the referee was biased was from his chambers. Now, barristers like to say that they're completely independent of all their colleagues in chambers, and that's what Lord Neuberger would say if asked. But of course, it's very difficult, I think, to take a completely independent view on a case being run against your colleagues. So there were those two problems, if you like, a kind of soft conflict of interest, and a bigger point in a way, which is, should a former president of the Supreme Court be advising on live litigation, let alone live litigation where the judge is being questioned, let alone live litigation which relates to serious miscarriages of justice? I think it was a huge error of judgment on his part, and he should have been asked about it.
Seems odd to me there isn't a strict rule about that. John, what do you think?
Those of us covering the inquiry were surprised that he wasn't called to give evidence in person. If you're a sub-postmaster who is already fairly angry about the justice system closing ranks, refusing to acknowledge there was a problem, I don't think it's a good look if the person who was responsible for advising on the recusal application is not brought before the inquiry. Lord Neuberger's written evidence was very stringent, as you would expect, that he felt he had acted properly and his advice had been correct. And I think it was, as Richard says, a real missed opportunity to bring him in and not just analyse the recusal, but also show to the victims and to the public that no one is above this inquiry and that this inquiry will leave no stone unturned.
Richard, huge sums have been spent and are still being spent on lawyers' fees by both sides because they're now disputing how best to compensate the postmasters for the miscarriages of justice. Is the adversarial justice system we use really suited to resolving wrongs like this effectively and in a timely way?
When you say wrongs like this, you mean compensation claims, or do you mean the whole shooting match?
I mean the resolution of the miscarriages, I think, that whole caboodle.
Actually, the miscarriages of justice bit was probably relatively cheap, but setting up a compensation scheme to be run by the post office and by a firm of solicitors involved in the Bates case was crazy, littered with soft conflicts of interest, potentially littered with hard conflicts of interest, clearly never going to satisfy the sub-postmaster victims.
And swallowing up quite a lot of lawyer money on both sides.
Well, we don't know how much of the Herbert Smith bill, which is the firm involved, is spent on the compensation side, but they've charged spectacular sums of money. So, yeah, very, very, very expensive and lots of infighting about little details. It would be much better to have a less adversarial model, an independent adjudicator, arbitrator, ombudsman who can deal with compensation claims. And you might know that the chairman of the Horizon Compensation Advisory Board has proposed that model in recent days. So having lawyers scrapping over every minute detail of cases is clearly not a productive way of spending public money and does not help the victims. One of the advantages of adversarialism, though, and it's shown in the Bates case, is if you've got a truculent, difficult, obstinate opponent, you can force things out of them. And the Bates case was the beginning of forcing the truth out of the post office. And if we hadn't had an adversarial court process, might not have been able to do that.
The Bates litigation was partly remarkable because it showed that the lawyers involved still hadn't quite grasped not only the injustices that had gone before, but the injustice they were still inflicting on people. So there was evidence, written evidence from emails in the inquiry that showed that one of the solicitors advising the post office effectively said to the post office, we will keep fighting until the victim side has no money. There was a finite amount of money that the claimants, the victims, had to play with, and the post office appeared to have no limit on the funds available to it. So there needs to be some accountability from the people in charge of the post office, but also the government, which was prepared to countenance this ridiculous litigation in terms of size and cost. And at no point did anybody on the post office side, be it the lawyers representing them or the government that was supposed to oversee them, actually step in and say, this is wrong, we're spending too much money, and we can't just bully the other side until they go away.
Okay, well, sadly, I think we need to draw this fascinating discussion to a close. We end these episodes by asking each of you, if you were in charge of the system, Lord Chancellor or whoever, what one thing would you do to prevent a scandal like this happening again? It's difficult because it's so multifaceted. I appreciate that. But if you can think of one thing, what would it be? Richard?
If I was Lord Chancellor, I would set up a task force to investigate and solve the problems of institutional dishonesty which are associated with the justice system. So I think that the way that powerful people, big organisations, use the courts and use lawyers can be deeply problematic. I think that relates partly to the way that courts are run. I think that relates partly to the way organisations are run. And I think it relates significantly to the way lawyers sell their services and provide their services and are regulated. That would be the one thing that I would do, and that, of course, allows me to do many, many, many other things.
Okay. What about you, John?
I would look to revisit the idea of lawyers being attack dogs in litigation, which seems to have permeated through so much of the post office scandal, and really make it very clear that an adversarial system does not give you carte blanche to treat people in this way.
Okay. What about you, Penelope?
I mean, it's interesting. We've talked about private prosecution, and I accept that it's not the driver of this problem, but I would like all non-state prosecutors or investigators to be scrutinised and examined a bit more closely. What about you, Rob?
Well, I was going to say something along those lines, because whether it's Crown prosecutors, public prosecutors, private prosecutors, there is a need for them to be able to have the time and the skills and the will to scrutinise the evidence and the public interest. They didn't, in Scotland and Northern Ireland, poke around the evidence enough. Why was that? They need to do that more, so whether it's training, some kind of scrutiny or inspection, but that area needs looking at.
Great. Thanks, Rob, John and Richard. And if you'd like to read John and Richard on the post office scandal, or see Richard in person delivering the Hamlyn lectures on lawyers' ethics, do read our programme notes for more information. And if you like this podcast, do subscribe. Thanks, everybody, and goodbye.
Goodbye.
Thanks for having me. Goodbye.
A pleasure. Thank you very much. Goodbye.